Good evening. My name is Tom Ebzery, spelled E-B-Z-E-R-Y. I'm an attorney, solo practitioner in Billings, Montana, and I'm a member of the LREC committee as well as being a member of the state bar for many, many decades. I have the distinct pleasure tonight to introduce our speaker, and this will be the final speech of your lecture of the group of our group. And I think that it's only that the topic tonight might be the most relevant and most current. So I want to talk to you about Anna Conley. He's an assistant professor in Missoula at the Alexander Blewett School of Law. She teaches federal courts. She grew up in Northern California, got out of there and went to Tulane University, and then got her degree in law school at George Washington, and LLM and a Doctor of Civil Laws from the McGill University Faculty of Law, and that's in Montreal. Anna teaches federal courts, remedies, global perspectives on law, international law, pretrial litigation, and generative AI in the practice of law. She's done extensive writing in this areas, and she has litigated many complex civil cases and participated in several rule of law initiatives and comparative law programs. Anna lives in Missoula with her husband, who is also a lawyer, and 2 children, and enjoys Missoula and has been there for quite a number of years. And so she has been the chair of the LREC committee and kind of has been the leader over the last number of years, and is the instigator of many of these programs that you're watching tonight and previously. We've also been told that there's a number of you have participated in quite a few of the lectures, and we're pleased about that. And if you're a newcomer, I think you're going to enjoy the topic. And I think it is current, probably the most current topic you could have right now, the presidency and the U.S. Supreme Court. So Anna is as a law professor, she's very well versed, but is always interested in questions you might have. So you can raise your hand and we'll recognize you if you have some questions along the line, and she'll do her presentation, but she's always interested in any dialogue that you might have. So without further ado, I introduce Anna Conley, professor.
Thank you, Tom. Appreciate that very kind introduction. Welcome everyone to our last Citizens Law School. As chair of the Law Related Education Committee, this has been a really fun year. I think we've really hit our stride with this program, our 3rd year doing this exclusively on Zoom in order to make sure that people across the state have the ability to participate. I've watched most of the participations this fall. I've learned a lot, and I've seen a lot of you really engaging, and I appreciate that. I want to give a special thank you to the State Bar. They stay late once a week for 8 weeks to make sure that we have this platform and to make sure that the Zoom works and everyone's registered. And so I want to give a big thank you to, especially to Jill and Earl at the State Bar for all of the support that they've given us. As I mentioned, or as Tom mentioned, I love questions. Unfortunately, this webinar format and the way that my computer is set up is Tom is the only person that can see the questions. I can't see them. So if you use your Q&A function, that is the best way to ask a question. And Tom will monitor the Q&A. And if there are questions along the way, he'll just let me know. And this is for you. This is a public service. I want it to be useful to you as the public. So if you have a question, if you want to follow up on something, please feel free to let me know. I'm actually really going to dig into the law here tonight. So if you are, wanting me to explain something in a little more detail or with a little more specificity, that's what I want to do for you. Okay. So I'm going to talk about three things. I'm going to talk really briefly about the concept of separation of powers in Article 1, 2, and 3 of our U.S. Constitution. So I'm not going to be talking about our state constitution tonight. I'm going to be talking about the federal constitution. Then I'm going to talk about executive power under Article 2 of the Constitution and executive immunity. I'm going to talk about the state of the law with executive immunity leading up to this summer's decision by the U.S. Supreme Court in the Trump v. U.S. case. And then I'm going to explain the Trump v. U.S. case, where it started from, how the court ruled and why the court ruled, and where maybe things are going to go from here. So talking about separation of powers, it's one of those terms that we've heard it a million times, but when you really just think about the words separation of powers, it's this concept that there are all these powers that the government has, and our founders in the 1780s, when they were creating our framework constitution to figure out how our government should operate, separated government power into different branches of government. So this is Article 1, 2, and 3 of our federal constitution. The framers put legislative powers in Article 1, executive powers in Article 2, and the judicial power in Article 3. So the idea here is this balance of power to not make any one branch too powerful. When you think about the concept of diffusing power, that can help you understand what separation of powers is. If you diffuse power across branches, then no one branch gets too powerful. So then you have to ask, who benefits from diffusing government power across branches? Well, we the people benefit. How do we benefit when the government diffuses power? We benefit because no one branch has total control over our life, liberty, and property. And if one branch does something that we believe violates our rights, we have redress with other branches that have independence and their own set of powers and authorities. So separation of powers, really this concept of diffusion of government power in order to preserve individual liberty. We also have separation of powers. What you see here is horizontal separation of powers, where you separate power between federal branches, but we also have vertical separation of powers between the federal government and state power. And that's that concept of federalism. That's what that term means, is what do the states have power to do vis-a-vis what does the federal government have power to do? We're not really going to touch on federalism much tonight, but it's just another example of the framers' genius of really trying to diffuse government power across branches and levels of government. So very quickly, the legislative branch. We're not going to get too into the legislative branch tonight, but that's Article 1. They make the laws. Bills must pass both houses and be signed by the president. So the concept with Article 1 is the legislative branch makes the laws. There are some specific powers that Congress has under Article 1, the tax and spending power. So it's Congress that can levy taxes and can allocate funds to different departments of the government and for different programs. When you think about checks and balances, you think about each article has different little ways in which the power that the article is giving one branch is creating a check of that power by other branches. So the presidential veto is an example where both houses might pass legislation, but the president can veto it. So that's a check. But the presidential veto can be overridden. So that's a further check, again, trying to diffuse that power. One thing that's come up a lot in the last couple of weeks is the legislative branch's ability to provide advice and consent to presidential appointments. And then one thing that we've seen in the first Trump administration is impeachment, the ability to impeach the president as well as other federal officials. There's also some restrictions that Article 1 puts on the legislative branch, including not being able to suspend the right of habeas corpus, not being able to make things illegal retroactively, and not being able to grant titles of nobility, which is a holdover from the system of government that we were leaving in the 1780s. So then we have Article 2, the executive power, and this is what we're really going to be focusing on tonight. So we have the 22nd Amendment. Interestingly, this was passed after World War II when President Roosevelt was seeking to serve a third term. It wasn't ratified until the 1950s. So this 2-year term limitation isn't part of Article 2. The 4-year terms are in Article 2, but the 22nd Amendment makes it clear that a president can only serve 2 terms. It's the only federal office in which we elect the president using the Electoral College. So every other federal election, the House, the Senate, that's just direct representation voting. Only the president has this electoral vote approach, where in most states, winner takes all. We have some basic requirements for the president. They have to be a natural-born citizen of the United States, 35 years of age, have been residing in the U.S. for 14 years. One thing that's come up more recently, they don't have to have they can be convicted of a crime. That's not something that Article 2 prohibits. Having been convicted of a crime to also be the president is not a problem under Article 2. So then the Article 2 lays out some of the responsibilities that the executive has, and the executive power is vested in the president. The president is the commander-in-chief. The president has this ability to pardon. One thing a lot of people don't know about the president's pardon power is that it's only for federal offenses. So the president cannot pardon people who have been convicted of state-level crimes, only people who have been convicted of federal crimes. Another one that has been pretty popular lately in the news is the ability to appoint ambassadors and U.S. Supreme Court justices and cabinet and heads of executive agencies. But the president can only do this with advice and consent of a majority of the Senate. So again, thinking about those checks and balances that are built into our framework constitution. At the end of the day, the executive's job is to enforce laws that Congress makes under Article 1. So the executive's job is to, quote, take care that the laws are faithfully executed. So Tom, I'm just going to keep on rolling unless there's some questions that I should address.
Go ahead. So far, we got a lot of listeners.
Okay, great. So when we think about executive power, the power that the president has, we think about where does it come from? There's basically 2 places that it comes from. It either comes from Article 2, which we just looked at, or it can come from Congress. So under Article 2, there's some things that Article 2 gives to the president, some powers that are exclusively the president's. For example, the pardon power. No other branch can intrude on this Article 2 pardon power that the president has. So you think of that as an exclusively executive power. On the other hand, the president also has some what we would think of as shared powers. And with shared powers, these are powers where Congress has related powers, so there has to be some interrelation and some coordination. So an example of what you might think of as a related or shared set of powers in a certain area is Article 1 says Congress has the power to declare war, but Article 2 makes the president the commander-in-chief of the Army and Navy. So when it comes to the military, both branches have powers that are related in this area. The other way that the president, the executive, can receive power, can receive authority to act, is when Congress delegates some of its power over to the executive. So those are pretty much the only 2 paths. And the only thing that I would add is that under Article 2, we have these express powers like the pardon power, but there can also be some implied powers where the courts might find that over time, there's an implied power that Article 2 has given the president. And then we have Article 3, the judicial power. And here, this is our current set of Supreme Court justices.
And we have a question, and I assume this had to do with the last topic before, and before the judicial, and it's from Trevor Bradford. Trevor, do you want to go ahead?
I think you have to read it, Tom.
Oh, I have to read it. Okay, you
Yeah.
can tell this is a local deal. Trevor asks, I'd like to ask a question, but I don't want it to be too polarizing. So
Yeah.
you want to, so how do we handle that one?
This is a civil public discourse. I am open to whatever questions people want to ask.
Okay, and so how does he get to ask the question?
He can
Or
just,
does he, what, how's that work?
he just uses the Q&A function.
Okay, you there,
Yeah.
Trevor?
I'll just keep on going and then we'll circle back.
His question is, when did the implicit powers of the president start to expand?
Yeah, that's a good question. I don't think
so
that's
too.
I don't think that's polarizing. I think
No.
that it's this idea of pattern and practice. So it's also a question that people, Supreme Court justices, attorneys, everyone would have a different answer to and different perspective. But the idea is that, for example, if you're thinking about Article 1 and Article 2 and Congress and the president, and maybe for 100 years, they've kind of gone along with a certain shared understanding of what the president's role is vis-a-vis a certain aspect of Congress, then there might be an implied norm that is built in that you could then look to that long pattern of practice that it seems like both branches have been comfortable with and imply that therefore, either Congress has delegated some level of power or that power is something that the branches generally agree would fall under an implied power of Article 2.
Okay, go ahead, Anna. Let's go on to judicial power.
Yeah, and it's related, right? Because it's the court at the end of the day that's going to decide whether pattern or practice has created an implied power. So the Supreme Court is in Article 3. It's created, it's got to be there. And then Article 3 also gave Congress the ability to create other federal courts, including the Federal Court of Appeals and the federal district courts, which Congress did at the end of the 1780s. And then what we call Article 3 judges, federal judges, have lifetime tenure. So once they're appointed, they cannot be removed unless they go through the impeachment process. And their compensation can't be diminished. So the concept of these protections is that if a judge could be removed for political reasons or have their compensation diminished for political reasons, then they might be less inclined to be independent and to make a politically unpopular decision based on their good faith reading of the law or interpretation of the law. So the idea is to insulate the court to allow for judicial independence through these protections of lifetime tenure and salary compensation protection. So I came across this quote, and I think it's a really apt quote for executive power, in particular executive immunity. This is a quote from a Supreme Court justice in the 50s that says, there is a poverty of really useful and unambiguous authority applicable to concrete problems of executive power. So what this quote is telling us is there's not a lot of law that tells us much concrete about the outer bounds of executive power and executive immunity. In fact, the multiple cases on the executive since the Trump first term have been vastly expanded. The amount of Supreme Court, or what I call SCOTUS, precedent in this realm. We had almost nothing for a long time, and now we have quite a bit more because of all of the questions that have come up in the last 8 years. So now I'm going to turn to executive immunity. So when you think about this concept of executive immunity, if you're vaccinated, you have immunity from virus. So you might be all around viruses, but you're vaccinated, so you're immune. So you can't get it. And the idea with executive immunity is the president may have committed a crime, may have engaged in violation of civil laws, but we don't get to ask that question. They don't get to be called before court. They are immune from being a defendant in a court proceeding. That's essentially what executive immunity is. It immunizes the president from being a defendant in a type of case. So For those of you that like the law school part of Citizens Law School, this slide is going to be for you. So we have to think about 4 different types of cases when we're trying to understand executive immunity and the state of the law leading up to the Trump v. US case. So the first one is civil cases in which POTUS, which is President of the United States, is the defendant. In these types of cases, the plaintiff is a person or a corporation who is suing the president as the defendant, and they're seeking a civil relief. So whether they're seeking money damages or injunctive relief. The next type of case is a civil case, but the president isn't the defendant. Someone else is the defendant, some other person or corporation. Instead, what the court wants from the president is information to proceed with their claim against someone else. And that's what we call a subpoena. And you use a subpoena when you're trying to get information as part of your evidence gathering in a case that doesn't involve that person as a defendant, but they might have been related as a third party. The third type of case is a criminal case in which a prosecutor, instead of an individual or a corporation, is bringing civil claims against someone else. So here you have an allegation that there's been a crime that's been committed. And what you want instead of money or injunctive relief is you want a criminal sentence, which usually results after conviction in incarceration or some other type of criminal penalty. So you can have the same situation where the prosecutor is, brought charges against someone other than the president, but the president has information about those charges and has been subpoenaed to provide that information to the court so that it can proceed with the charges that the prosecutor has brought. So we have existing case law in 2 out of 3 of these situations, but none of these are the situations of the US v. Trump case. The US v. Trump case is a case in which you have a criminal case and the president is the defendant. So you have a prosecutor who has a criminal charge brought against the president himself. So what I'm going to do is I'm going to tell you about some of the existing cases that we have with regard to these other types of cases and the tests that were created by the Supreme Court for these other types of cases, because that really helps us get some background for understanding the Trump case that we're going to be talking about tonight. So the first one is that first category, where it's a civil case where the president is the defendant. In this case, this was a 1982 case. You have Mr. Fitzgerald. He was the plaintiff, and he worked for the U.S. Air Force. He testified before Congress about some cost overruns that the U.S. Air Force had engaged in, and essentially he was a whistleblower. So then he was dismissed from his job after his department was reorganized and his job was eliminated. And he went through an administrative process which found that his job reorganization and elimination was basically retaliation for whistleblowing. So he subsequently, after Nixon was no longer in office, sued executive officials and President Nixon, and he alleged retaliation and sought money. So here we have a civil case in which the president is a named defendant. So here's the most important thing prior to the Trump case that we're going to talk about tonight. In this Nixon v. Fitzgerald case, 5 out of 9, it was a 5-4 decision. The U.S. Supreme Court said that the president has absolute immunity from damages liability for acts within the outer perimeter of his official responsibility. So absolute immunity means complete immunity, no questions asked, total. You cannot sue the president if you are seeking damages liability. And that damages liability is based on an act the president took within the outer perimeter of his official responsibility. So what does that mean? We're going to break it down a little bit more, but first I want to explain how the court decided this. The court said, look, it's in the public interest for the president to take bold and unhesitating action and to be able to exercise discretion without apprehension and without hesitation. The court said it's going to divert the president's attention if he's constantly worried that what he's doing is going to result in him being sued for damages. And that diversion of the president's attention is going to negatively impact all of us because we are all hoping that the president is focused on doing his job without worrying about whether he's going to be sued. So these are the public policy considerations behind this absolute immunity in civil cases holding. The court said, you know, we have to remember separation of powers, and under Article 2, the president has a lot of discretion to make choices using the authority that Article 2 has given him. And we should observe that separation of powers and be deferential to that. The president is making a lot of very hard decisions, very sensitive decisions, very important decisions, and we shouldn't allow him to constantly be second guessed. This is essentially the underlying policy of this creation of absolute immunity in civil cases. So when you think about what the court did here, it gave the president a lot of freedom to not be sued for things that the president was doing within his official responsibilities. So the court, knowing this, said, don't worry, there's lots of safeguards in place that we can rely upon as a check for executive power now that we've given the executive this absolute immunity. And some of these safeguards that the court looked at were impeachment, for example. President can be impeached. A president is under constant scrutiny by the press. A president has oversight by Congress. A president, especially in their first term, might want to earn re-election. A president needs to maintain prestige if they want to be an influential president. And a president has a traditional concern for his historic stature. So these are safeguards that the court said the president is still going to behave responsibly even with this absolute immunity because of these safeguards. So if we think about it this way, you've got this outer perimeter that within it is the president's official responsibilities. And as long as the president's acts are within that outer perimeter, the president has absolute civil immunity. But if the president acts outside of that perimeter, then the president does not have any civil immunity. So then the president could be civilly sued for damages. And ultimately, the court said that the claims by Mr. Fitzgerald were within the president's official responsibility because the president has the ability to reorganize executive departments and engage in personnel decisions. So Mr. Fitzgerald was out of luck because the president had absolute immunity with regard to his claims since they were part of the president's official responsibilities. So if we go back to this slide where we talk about all the different types of cases and all the different types of immunity, we now have the first rule, which is in civil cases, the president has absolute immunity for damages liability for acts within his official responsibility. Questions on that before I keep rolling? Okay.
No questions.
All right. So now we're going to look at this orange type of case, a criminal case where the president isn't a defendant, but the court or one of the other parties wants information from the president. So this is the first U.S. Supreme Court case dealing with Trump, and this is the Trump v. Vance case. And in this case, you had a state court, the New York State Court, you had the New York DA open an investigation into business transactions involving individuals who may have violated New York state law. So then the New York District Attorney served a subpoena on this company that was Trump's personal accounting firm. And the subpoena directed the accounting firm to produce quite a bit of information about Trump's finances, including tax returns. So then Trump filed in federal court and said, hey, court, don't let them make me turn this stuff over. I don't think I should have to turn over this information that they've asked me for in this subpoena, because I think a sitting president should have absolute immunity from state criminal process. And what state criminal process means is request for information by subpoena in state criminal proceedings. So the US Supreme Court in that case then did a balancing. And whenever you're dealing with separation of powers types cases, the court's always going to be balancing, thinking about the different impacts, both good and bad, on the branches of government based on how they proceed. So the court first said, okay, what's the public's interest in giving the president immunity from subpoena? And then said, and what's the public's interest against giving the president immunity from subpoena? So there was this concept that the president should be able to speak freely, should be able to speak in a harsh, maybe blunt, objective way when he's going about his decision making. And we're a little bit worried in the same way that they were worried with the Fitzgerald case, that if we make a president turn over all of their information or turn over all of their records, then maybe they'll be less candid, and the public has an interest in the president being candid, blunt, and objective in their day-to-day operations. So there was some interest in preserving the confidentiality of records that the president might have. But then ultimately, the court found that the president was not immune, that he did have to turn over what he was asked to turn over. And that's because the court looked at all of this other stuff. The court said the goal of judicial proceedings in criminal cases is to make sure that the guilty don't escape and the innocent don't suffer. And the way that the criminal proceedings are able to do that is by having information, by having facts. Then the jury can figure out whether or not the person is actually guilty or actually not. And the only way that a jury or a fact finder can make sure that the guilty don't escape and the innocent don't suffer is to get facts. And the only way to get facts is to make sure that people respond to subpoenas. So ultimately, the court said that the interest against presidential immunity from subpoena outweighed the interest in favor of immunity. So then if we keep building up to the existing rules leading up to the US v. Trump case, now we see the president has absolute immunity if he's a defendant and it's a civil case, but has no immunity if it's a criminal case against someone else and the president is just being asked for information through subpoena. All right, so now I'm going to start talking about the US v. Trump case. So
we got one more question from Trevor. He said, well, I'm not particularly troubled by the holding in Nixon. This quote, safeguards have no practical impact. So my question to you is, in your opinion, which of these safeguards which you listed have real teeth?
That's a great question. And I've kind of thought that same thing. I can go back to those safeguards.
Okay.
So, I mean, impeachment is still a safeguard, right? Congress still has the ability to impeach the president. That hasn't changed. I think one of the big safeguards that's changed is scrutiny by the press. And that's just because we have siloed media now, where you have one group of Americans getting one set of facts and another group of Americans getting another set of facts. And algorithmic social media, and really you end up with, I think, less constant scrutiny by the press, just given that we have the siloed media that we have today. Congressional oversight, I think, is still a safeguard. Desire to earn re-election is certainly a safeguard for a first-term president, but it is not necessarily a safeguard for a second-term president. And then these next two, thinking about the president's view of maintaining prestige and stature, traditional concern for the office, I think that that's kind of up for debate. And I think different people would have different views about different presidents' approach to those two issues, and what maintaining prestige means to one president might mean something else to another president. What one president might want to be remembered for in history might be different from another president. So I think that one is, I'm not sure. I've only lived the life that I've lived, so I haven't seen the two centuries of American history. But from what I've seen, I think that there's some eroding of these safeguards.
Thank you. Go ahead.
Yeah. Okay, so the US v. Trump case. We start with November 18th, 2022. The U.S. Attorney General appointed special counsel to investigate efforts to interfere with the lawful transition of power following the 2020 election. And then that led to August 1st, 2023. A grand jury returned an indictment against Trump. So here's just a screenshot of the initial indictment that was filed August 1st, 2023. United States of America versus Donald Trump. And you can see this was filed in the United States District Court for the District of Columbia. You can see that the introduction of the initial indictment filed was that Trump lost the 2020 election, and despite having lost, he was determined to remain in power. And the remaining 45 pages of the indictment talk about different facts that lead the grand jury to charge Trump with 4 criminal counts. 1, conspiracy to defraud the U.S. by overturning election results. 2, conspiracy to obstruct an official proceeding. In this case, it was certification of the electoral votes on January 6th. And then conspiracy against rights of persons to vote and have their votes counted. So the next thing I'm going to do is walk through some of the factual allegations in the indictment. But before I do that, I want to explain what an allegation is. An allegation is not a proven fact, it's an alleged fact. And essentially what happens is the grand jury will issue an indictment based on probable cause that a crime was committed. Then allegations are set forth in an indictment. And ultimately, if you don't end up with a motion to dismiss or immunity, that then will go through a discovery, exchange of evidence process, pretrial motions, and ultimately go to a jury trial where a prosecutor has to prove beyond a reasonable doubt all of the factual allegations that have been set forth in the indictment. And if all of those elements of the crimes have been proven through facts that are proven, then the person can be convicted and then sentenced. So what I'm talking about are the allegations that have been set forth in the indictment. So essentially, Trump lost the 2020 election. After the election was called for Biden, Trump took several steps. The first is basically publicly, consistently asserting false claims of election fraud, trying to get the Georgia Secretary of State to, quote, find him votes, trying to get alternative slates of electors certified in 7 different states, including Arizona specifically, trying to get the U.S. Department of Justice to investigate voter fraud without foundation in fact, pressuring the Vice President, Mike Pence, to reject the actual electoral votes and send the electors back to states, and taking advantage of the chaos and delay that was created in the January 6th insurrection. So I'm going to talk just a little bit more about some of these allegations. The idea was that Trump pressured the Georgia Secretary of State to find enough votes to get him to win the electoral votes for the state of Georgia. That call was recorded by the Georgia Secretary of State, and it's widely available online if you want to give it a listen. Then there was the Speaker Bowers, who was the House Speaker for the Arizona House of Representatives, was called by Trump and co-conspirators to essentially delay or change the process of counting electoral votes for the state of Arizona. And this is a statement in the indictment made by the House Speaker. As a conservative Republican, I don't like the results of the presidential election. I voted for Trump and worked hard to reelect him, but I cannot and will not entertain a suggestion that we violate current law to change the outcome of a certified election. So there was pretty open public resistance by the Arizona House to this pressure. Then there was the allegation that Trump urged Vice President Pence to not certify the electoral votes January 6th. The vice president oversees the counting and the certification of the electoral votes. And there were meetings, allegedly, as well as lots of public statements trying to pressure Pence to delay or not certify. Then there was the allegation that Trump used the federal Department of Justice to try to investigate knowingly false claims of election fraud. And then there are allegations that Trump essentially took advantage of the delay and chaos that ensued from the insurrection on January 6th to not have election results certified. So what happened? We have the appointment of the special counsel. We have the grand jury indictment with all of the allegations I just went through. Then Trump files a motion to dismiss the indictment. He files this on multiple grounds, including executive immunity. So then in December of last year, the DC District Court, which is the first court that heard this, denied the motion to dismiss and held that the president has no executive immunity from criminal prosecution whatsoever. Then Trump appealed that to the district court, the DC Court of Appeals, which affirmed that Trump has no executive immunity from criminal prosecution. Then Trump appealed that to SCOTUS. So then we get to the SCOTUS decision. Here we have the Supreme Court justices who ruled. We have a majority opinion with 6 Supreme Court justices. The Chief Justice Roberts wrote the opinion. You have Roberts, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett joining. You have a concurrence from Thomas that's raising questions about the special counsel role. And then you have 3 justices dissenting, Justices Sotomayor, Kagan, and Jackson. Sotomayor wrote a dissent and Jackson wrote a dissent. So now I want to talk a little bit about what the majority held and why. So remember that Fitzgerald test that said that if you're within the outer perimeter of the official responsibilities, then the president has absolute immunity. Well, here, the justices changed this a little. They said, if you are within the outer perimeter of the president's official responsibilities, the president has a presumption of criminal immunity. So we go from absolute civil immunity to a presumption of criminal immunity. And the thing about this holding is the way that the court interpreted official responsibilities, what it means to be within this circle, includes a lot of things. Basically, it includes all actions not manifestly or palpably beyond his control. So something would have to be crystal clear, absolutely outside of the president's official responsibilities to be outside of this circle. It includes powers that the president gets from Article 2, as well as powers that it might share with Congress, as well as powers that Congress might delegate. Now, a prosecutor could overcome this presumption of criminal immunity if the prosecutor could show that the criminal statute that the prosecutor is using to say that there's been a violation, if the criminal statute that's criminalizing the behavior at issue wouldn't intrude on the executive branch's functions and authority. So this is a new test. This is the first time in the history of our nation that we have a test for executive immunity for criminal prosecution. So we're not really sure exactly what these words mean in practice because we just don't have cases on these tests. Outside of the official perimeter of the president's official responsibilities, the president has no criminal liability. But again, remember that the circle is pretty big when you think about the definition of the outer perimeter that the court provides. Here's the thing that's really different. We have another category that the majority creates. The majority says there's also these core constitutional powers. And these core constitutional powers result in absolute criminal immunity. So if a power is given to a president and the president alone, it's not shared, it's not blended, it's not delegated, it's just something that only the president can have, then the president has absolute criminal immunity. Congress can't criminalize these types of anything within this core zone, and the courts can't review it. So thinking about the pardon power, for example, the president, that's a core constitutional power of the president. No other branch has it. No other branch really has a related power. And so that would be something that the president would have absolute criminal immunity for pardoning. And this is something that the dissenting justices take issue with, because in a broad reading of this test, if, for example, the president took bribes to pardon people, technically there'd be absolute criminal immunity for that act. Something that's really important, that's hard to wrap your head around, is that this test is absolutely free of any concept of intent. It doesn't matter what the intent of the president is. That's not on the table, because the court says we shouldn't have a look inside of the president's mind. That's something that would violate separation of powers. The question is truly just the nature of the act. If the nature of the act is within the outer perimeter of official responsibilities, or if it's just one of those core powers, the president could do it with overt criminal intent, and it doesn't matter. You would still have immunity. There was a lot of discussion in the majority opinion about the same types of concerns that we saw in Fitzgerald. The idea that the president needs to act bold and unhesitating action, that we don't want to make it so the president is worried about criminal prosecution. We want the president to be able to do his job because the public has an interest in the president being able to do his job. So then we have the court looking at the allegations against Trump and seeing if it can piece where these allegations fall within this framework. So the first thing that the court says is, well, we have these allegations that Trump attempted to use the Federal Department of Justice to investigate knowingly false election fraud claims. And the court says that those types of allegations where you have the president directing the Department of Justice to do something, those are core constitutional powers. The president has the absolute ability to remove the attorney general, and the executive has the absolute ability to decide how to enforce crimes. That's prosecutorial discretion. That's the executive's job, is enforcing laws. And so the courts cannot look and second guess any type of action where the president is directing the Department of Justice to do something. That's a core constitutional power, absolute immunity. Then the court looks at this question of Trump trying to force the vice president to certify false slates of electors and pressure the vice president to send the electoral votes back or to delay it. And the court says, we're not 100% sure about that. Because the vice president is part of the executive branch, we think that that's part of the president's official responsibilities. So there's a presumption of criminal immunity here. But we're going to send that back to the lower court to figure out whether or not that's within that outer perimeter of official responsibility. And then for the rest of the cases, the rest of the allegations, the false statements that the election was fraudulent, the court says it's not clear whether false statements about the election being fraudulent, whether that is entitled to this presumption of immunity or not. It was interactions with people outside of the executive, sometimes with private individuals. And the court comes to the same conclusion with regard to the Georgia Secretary of State and Arizona House Speaker discussions. They're not sure. They want to send it back to the lower court for the lower court to make a determination where those allegations would fall within this framework that was created. So that's, in essence, the holding of the majority opinion of the Trump case. And then it got sent back to the lower court, and then special counsel filed an amended indictment that parsed out some of whether the acts that were alleged in the indictment were official or not, and provided some additional information with this new test in mind. But before we go to what the next steps are here, I would also just tell you a little bit about the dissents. So Justice Sotomayor ended her dissent with fear for our democracy, I dissent. This is kind of a big deal in the SCOTUS world because usually the term respectfully comes before the word dissent. So usually when a Supreme Court justice dissents, they say, I respectfully dissent. But here, we don't get that respectfully. We get, with fear for our democracy, I dissent. And Justice Sotomayor says, the text of the Constitution doesn't give the president immunity. When you look at the framers' intentions, when you look at all of the stuff that was going on historically at the time of ratification, it doesn't, neither history nor the text of the Constitution nor the president nor the precedent of this court would warrant this type of expansive immunity that the majority gave the president. The dissent is not convinced by this sort of balancing and focusing on, we don't want to intrude on the executive. We don't want to make it hard for the executive to do his job. And there's a real focus on the long-term negative consequences of this ruling by the majority, and this concept that there's now this shift between the president of the United States and the American people. As I mentioned, Justice Sotomayor talks about, if president takes a bribe in exchange for a pardon, that would be immune. If the president ordered the Navy SEAL 6 team to assassinate a political rival, that would be immune. And in the majority opinion, Justice Roberts takes a lot of issue with some of this type of language in the dissent and calls it fear-mongering. So you can see there's a real just difference of basic opinion about how to even answer this question between the majority and the dissent. And then you have Justice Jackson's dissent, who also does not respectfully dissent, but says, because the risks of power the court has now assumed are intolerable, unwarranted, and plainly antithetical to bedrock constitutional norms, I dissent. She really focuses on the rule of law, and this placing the president above the rule of law, really focuses on the concept that criminal law is based on this idea of individual accountability, that each person is accountable for their acts, but they have this entree of due process protections, including the right to counsel, the right to this very high burden of proof, the right to jury of their peers, and that the majority decision to give these core power absolute immunity and this presumption of immunity for this wide swath of official conduct is really changing what we think of with this individual accountability, that every American in the country is individually accountable other than this one person. Again, she focuses on long-term issues like being able to assassinate political rivals or critics and being completely immune, being able to instigate in an unsuccessful coup, for example. And one thing I think is really interesting about Justice Jackson's dissent is she looks at how this impacts Congress when you're thinking about separation of powers. She says, you know, what you're doing is you're stripping Congress of the ability to make laws that apply to everyone. And you're actually giving courts the power to decide whether the president is subject to Congress's laws instead of just letting Congress make everyone subject to their laws. So she saw it as a little bit of, I would think, a power grab by the court, as well as a stripping of power of the legislative branch. So I can stop there if there's more questions.
All right, and I think things are warming up. We've got some, I'm just going to read a few of these and you can choose to go for them or you can sidestep. Let me read the first. The fact that there is no, quote, intent element in the Trump versus U.S. ruling is antithetical to all criminal law precedent. So my question is, if you were to try to improve the majority opinion consistent with the criminal law precedent on intent, how would you do it? Why don't you think about that a minute? And then there was another question was, are you going to address the Supreme Court's delay in taking up the Trump versus U.S. Case, which they basically sat on for several months, as I think we remember? And the third is an inquiry for you is, and I think the answer is yes, did the amended indictment by the special prosecutor go through the grand jury process? So I can repeat, but those are the questions.
Those are great questions.
Yeah, they are.
I'm not sure that I'm able to improve on the majority opinion. I myself, very personally, I'm sold on the lower court opinions that there shouldn't be criminal immunity for the executive. I do, though, understand the concerns, but as I mentioned before, I think a lot of the safeguards have eroded, and I think it does put one person above the law in a way that I think our founders weren't intending to do. I really like the question of how could we bring intent in and have some level of immunity. And I don't know the answer to that, but I think that is the million-dollar question, right? Like, because the whole concern of the court was we don't want to try to pull back the curtain of the president's mind and see what he intended to do. But I think the dissent is right in saying, gee, when you have these situations where it's obviously bad intent, where it's obviously criminal intent, do we really have to just ignore that? So I don't think I have a good answer for that, but I think it's a good question. As far as the delay, I don't know. I don't know what to say to that. And then the amended indictment, whether it went back through the grand jury, that's a great question. And I don't know the answer to that either, but that's a good question. I'm
I
assuming
think
that
it
it
did.
did, but I don't
And
know.
I think he did take, Jack Smith took it to the grand jury, but I could be wrong also.
Yeah. So I'll just finish up, just thinking about what's next for this case now that we have Trump as the sitting president starting in January. Um, in the news, there's been a lot of news that the special counsel is going to wind this case down. It's a term that's being used, wind the case down. And so you think about, why would special counsel dismiss at this point, or why would special counsel recommend to the attorney general to dismiss? There's long-standing Department of Justice position that a sitting president, who now, like Trump, was a former president, but he's soon to be a sitting president. And that's another thing that's just, this is such an unprecedented situation. Not only had we never really dealt with criminal immunity before, but now we have this very rare situation where you had a president and then that was not the president, and now it's going to be the president again. So it's kind of a perfect storm of issues with regard to, and timing with this first time that we've been trying to figure out this criminal immunity question. Because pretty much everybody agrees that a sitting president can't be criminally prosecuted, because that truly would distract the president from actually having to be a criminal defendant while in office. And so because of that, really, this case can't proceed as soon as the president is sworn in and is a sitting president. It's very likely, in addition, that the new attorney general under a second Trump term is going to fire the special counsel and dismiss this criminal case. So what I have read in the news is just this idea that right now, special counsel could recommend dismissal, and the attorney general would be able to provide a public report explaining reasons for the dismissal, potentially engage in some equitable tolling type of actions that would allow the prosecution to restart when Trump is no longer the sitting president. And then, the question of whether the president can pardon himself is not a question that's ever been asked or answered in our nation's history. And we don't really want to create bad precedent in that way. And so that would be a pretty dangerous question to call, I think. Also, questions about whether a sitting president can order dismissal of a special counsel investigation about him. Those are just some really tough questions that I don't think we want to necessarily call. So those are my armchair quarterback questions about maybe why it is that we're looking at this news that's talking about winding down this case.
All right, Ann, I got a few more, and I know we're running up against a time deal, but we have one question. Do you believe changes in the political sphere and the media has resulted in more hostility and polarity between the Supreme Court justices you mentioned that in terms of the dissent in the last case. If so, how do you believe this could impact their upcoming decisions?
Yeah, I'll just give you my personal opinion on that. There has been a change in tenor in Supreme Court decisions over the past couple of decades. It started really in the 80s, and famously, Justice Scalia in a dissent he said, people will die because of the majority's decision in an executive power case involving enemy combatants, I recall. So we just saw a lot more really strong language and a lot more really taking the other side to task in dissents and majority opinions. And so I think that's something that has increased over the decades and over the centuries. And I don't have a crystal ball, so I hope that it doesn't continue, because I don't think it's good for the perceived legitimacy of the court, and I don't think it's good for civility, and it's not really about the merits of the claims or the opinions or the arguments. And so I don't know if it's going to continue or not.
Okay, one last one. Can a sitting president be charged by the International Criminal Court, or whatever that's called? And
I love the international law question. That's a great question. So the problem with that is that we, as the United States, haven't ratified the Rome Convention. And so because we haven't ratified that treaty, you would only be able to charge our people if they were engaging in activities in other countries that have ratified that treaty. So I don't know that a sitting president could be charged before the ICC, but that would be something that would be way down the line of reasons why a sitting president of the United States could not be charged by the ICC prosecutor.
got you. All right, I think those were our questions, and I think we're right on the time line, and I want to thank you on behalf of the participants for your excellent presentation and your thoughtful answers. And I think that we did a good job tonight. You did.
So did you. And I just want to thank you guys all again for joining. It means a lot to the law school and to the bar and just for Montana community for us to make this space to learn about the law. And so I just appreciate your interest. Thank you.
So thank you and good night.